Hello, good afternoon, everybody. How is your day going? It is our prayer for you that you have a fruitful and rewarding day ahead of you. You're welcome to Legal Clues on Emirate Radio. And of course, you know that on Legal Clues, we give you legal tips on how to be intentional about living a crime-free life. We give you tips that can help you to make informed decisions in life, that can help you to have access to justice, that can help you to know your rights and obligations as citizens of Nigeria. So on today's episode of Legal Clues on Emirate Radio, we'll be discussing the topic matrimonial causes. Matrimonial causes. A lot of people will not know what it means when we say matrimonial causes. It refers to legal issues or disputes related to marriage. So when you hear matrimonial causes, we are talking about legal issues or disputes that are related to marriage, that can arise from marriage. The term matrimonial causes is often used in legal context to describe a range of issues that arises in marriage. So like I said, when you hear of matrimonial causes, it is used to describe issues that can arise in marriage or that are associated with marriage, which can of course include divorce, annulment of marriage, separation, dispute over custody of children, spousal support, and property division. So, like we said, legal causes, matrimonial causes are legal matters that are associated, accompanying marriages that can, sprout out of disputes from marriages, and it's usually between married couples. So it can involve a lot of things. It can range from nullity of marriage, validity of marriage. It involves your grounds for divorce, can involve separation, custody of children, access of children, divorce, and a host of others. So there are a lot of things that cannot be associated with marriage that sometimes when it arises, the spouses might be in dilemma as to what to do. So matrimonial causes are wide range of disputes that can come out of marriage. Matrimonial causes proceedings are governed by what we call the Marriage Act and the Matrimonial Causes Act. So these are the laws that governs matrimonial causes. The first one I have with me that I want to talk about is nullity of void and voidable marriages. A lot of people are not even aware that there is something called void or voidable marriage. You can be in a marriage, you think you are married, but your marriage is actually a void one, or is a voidable one that can be annulled upon somebody's application. So what does it mean to have a void marriage? What does it mean to have a void marriage? A void marriage is one that will be regarded as, void by a court of law. It will be regarded by a court of law, or in any case in which it arises, that the existence of the marriage in issue goes to nullity. What we are saying is that a void marriage is one that the court will pronounce void because of some issues surrounding it. It will be regarded as never it will be regarded as if it has never taken place. You understand? It will be treated by both parties as if it has never occurred. And it's not as if when it's found wanting in the court and they will say you should go for divorce. No, it will be annulled like the marriage never existed. So simply put, a void marriage is a marriage that is invalid as they are considered to be unlawful. They are invalid as they are considered to be unlawful. A void marriage is a marriage that is dead upon arrival. A void marriage is a marriage that is dead upon arrival. It is a marriage that is flawed in its validity, but it continues to exist until a nullity order is being granted in court. It is void upon arrival. It is, as if it has never existed. It's considered to have never been in existence. So what are the things that can happen that will make a marriage void? What are some things that can occur in a marriage that will make the marriage to be as if it has never existed? Number one is existence of a lawful marriage, where a spouse is already married, legally married to another person under the law. Of course, the person. Statutory marriage, for example, marriage, conducted under the law, statutory marriage. You cannot go to marry another person while that first marriage is subsisting. When the first marriage is subsisting, a competent statutory marriage is subsisting, you cannot go and do another marriage elsewhere. That second marriage will be considered void. Void ab initio, dead upon arrival, as if it has never occurred. Of course, a man who did a customary marriage is usually said that he can marry as many wives as he wants under the customary law. However, if a man did a statutory marriage, it means he cannot marry another person, either statutorily or customarily, until he dissolves the earlier statutory marriage he has done. So he needs to first do a divorce before he can proceed to marry another person under any form of marriage. But where the first marriage is subsisting, very much valid, that second marriage is void ab initio, dead upon arrival, as if it has never existed or occurred. Another instance is where a man has done a customary marriage with a person. He cannot go ahead and do another statutory marriage with another person. Such a person can decide to upgrade his earlier customary marriage, of course, to a statutory one. We have cases where people just do engagement. We call it engagement in our term here, but it's a customary marriage. Some people do engagement, then proceed to court, the registry, to do their court marriage, like we call it. So you can do that. You can upgrade an earlier customary marriage to a statutory one with that same partner, not with another person. So some of these instances can, cause a marriage you think is existing to be declared void, to be annulled. Where either of the two instances that I mentioned is where it exists, such a marriage can be nullified on the basis that it is a void marriage. And once it is nullified, it is deemed as if the marriage has never been done. Another instance where a marriage can be declared void is from its prohibited degree of consanguinity and affinity. When we come back from the break, I'm going to be explaining this. But in the meantime, relax, sit back. We'll be right back. You're welcome back to Legal Clues on Emirate Radio, and as we said, we are discussing matrimonial causes for the purpose of benefit of people just joining us. Matrimonial causes are legal terms for disputes arising from marriage, dispute that can be associated to marriage. We could of course include divorce, custody of children, annulment of marriages, separation, access, division of property, and a host of others. And we are talking about void marriages, instances where a marriage will be declared void. Instances where a marriage will be declared void. We have said it where a statutory marriage exists between a partner and that person goes ahead to contract another marriage with another person. The second marriage will be declared void. We have also talked about a customary marriage existing, then the person cannot go ahead to do another marriage with another person, except of course if you want to upgrade the customary marriage with that same partner. Another instance where of course a marriage can be declared void is where it is on affinity and consanguinity. Prohibited degrees of consanguinity and affinity. This is also another instance where a marriage can be declared void. Simply put, it means consanguinity means relationship by descent from the same ancestor. Probably brother and sister getting married to themselves. It's possible, probably they didn't know, they were separated, and eventually they discovered that they are related by blood. Of course, they are married. The marriage between them can be declared void, can be annulled by the court. Affinity means ties between individuals related by marriage. Where a marriage celebrated by parties is said to be within the prohibited degrees of consanguinity and affinity, it means that the marriage will be void under Matrimonial Causes Act. Affinity, for example, this is a wife, as a wife now, the sister of the wife is related to the husband by affinity. So, any marriage between them, of course, can be void, can be annulled based on the prohibited degrees of instance, of course, where a marriage can be declared void is failure to obtain consent. This is where neither of the parties to a marriage consents freely to